Hello, everyone. Thank you for coming to today's CLE. We are here with Innocence Project Delaware, who is partnering with the ACLU today to present on innocent and incarcerated, how Delaware can release those who are wrongly imprisoned. I am thrilled to be introducing Jessica. Oh, I'm going to mispronounce your last name, so I'm going to let you introduce yourself. Here's Jess.
Thanks, Melissa. Hi, everybody. It's great to see you. My name is Jessica Aletta. I am the co-executive director and the director of case intake and investigations at Innocence Project Delaware. I'm going to pass it over to Sophia to continue her introductions.
Yes, thank you, Jess. My name is Sophia, and I am the Community Engagement Manager here at Innocence Project Delaware. And today I'm looking forward to learning with all of you and teaching about our 501c3 nonprofit. And I'll hand it back to Melissa.
Fantastic. So we do have a couple folks on the call today who are receiving CLE credit. So if you are here as a paying member to receive CLE credit, I'm going to drop a link in the chat right now. This is a form. We will be reciting codes throughout this event. You must record those codes into that document that I've just dropped. And on that note, I'm going to present code number 1, which is 762 HGI. Again, code number 1 is 762 HGI, and that is code 1 if you're receiving CLE credit. And I'm going to pass it along so that we can hear from our fabulous partners.
Great. So thank you all for joining us today as we learn about Innocence Project Delaware. Today's webinar is entitled Innocent and Incarcerated, How Delaware Can Release Those Wrongly Imprisoned. And we're really excited to be here alongside coordinators from the ACLU of Delaware. We can advance. Oh, awesome. So a bit about who we are. We were founded in 2018, and we are the only organization in the state that's dedicated to identifying and investigating claims of actual innocence. We work tirelessly to uncover new evidence, challenge flawed convictions, and fight for justice. We collaborate with experts, forensic analysts, and legal professionals, and strive to ensure that innocent individuals are not only freed from incarceration, but also given the support that they need post-conviction to rebuild their lives. Our mission can be thought of in 4 parts: advocacy, training, educating, and reforming the system. So for the first part, advocating, we strive to investigate and represent those with claims of actual innocence in Delaware. We train, provide hands-on experience for law and criminal justice students, educate, raise awareness about wrongful convictions and legal reforms, and reform, push for these policies to prevent innocent people from being wrongfully convicted. If we could go to the next slide, please. Thank you. So today we have a couple of learning objectives that hopefully by the end of the hour, we can cover all of these. We want you all to leave with an understanding of the key causes for wrongful convictions. We want to analyze the impact of wrongful convictions, explore the legal mechanisms for correcting wrongful convictions, gain awareness of policy and legislative reforms to prevent wrongful convictions, and empower participants to advocate for change. So hopefully, again, by the end of the hour, we'll address all 5 of these things so everyone can feel like they've left learning something about wrongful convictions and how to address them in our small state of Delaware. So to start off, I just wanted to cover what is a wrongful conviction. So a wrongful conviction occurs when a factually innocent person is convicted of a crime they did not commit. And wrongful convictions are a symptom of a broken legal system that must be fixed. Since 1989, more than 3,650 wrongfully convicted people have been exonerated in the United States, including over 195 people who were sentenced to death for crimes they did not commit. Studies estimate that between 4 and 6% of people incarcerated in United States prisons are actually innocent, which would equate to about 300 innocent people that are serving time for crimes they didn't commit in Delaware alone. On average, an innocent person is exonerated every 54 hours in the United States, which may shock some of you. I know this statistic always shocks me. And another statistic I wanted to add today is that 30% of wrongful convictions are based on no crime cases, just tragic accidents. So what this means is that it could be that a fire was incorrectly ruled an arson, or a child getting injured was incorrectly ruled a murder. So it's important to keep in mind and to note that about just under a third of exonerations are from no crime cases.
So we're going to start with some contributing factors of wrongful conviction. We have 6 listed here because they are the most common that you see in wrongful convictions. Many of these are probably familiar, but for most of you on the call. And so we look at the most common causes because many of these overlap in our cases. And so of all of these 6, we have cases in Delaware that we're currently investigating, or clients that we have currently retained that have these common causes within their cases. And so the first one is eyewitness identification. We have junk science, false confessions, jailhouse informants, inadequate legal defense, and official government misconduct. And so we'll go through each of these in the next few slides, a very brief overview to give you insight into why these are so problematic and why they're usually the contributing factors to a wrongful conviction. Next slide, thank you. So we're going to start with eyewitness misidentification. So eyewitness misidentification is one of the greatest contributing factors to wrongful convictions. It plays a role in more than 70% of convictions that were overturned through DNA testing nationwide. And so eyewitness identifications remain among the most used and compelling evidence about criminal defendants. I would like to sit here and be able to tell you that Delaware is immune from this, but it is not. We have a lot of cases that we're investigating right now where this is the main issue in the case. And so the problem with eyewitness misidentification is that eyewitness confidence grows over time. And so we know that memory is not a recording. We are imperfect as humans. And so we know things like stress, cross-racial identification, suggestive lineups, these all affect our memory. The problem with eyewitness misidentification is that if a criminal defendant has been, identified by a victim very early on in a case, but that victim is not 100% certain at the time they make that identification. But through interviews with police and maybe testimony, when they testify at court, it becomes more confident over time. And so by the time they're bringing this evidence into court against a criminal defendant, to the jury, it may appear that this is solid. There's no way this could be anybody else. And an example of that is the Ronald Cotton case. This was a case in North Carolina. The 2 men pictured in the photo on the screen, left is Ronald Cotton and right is the person who actually committed the crime. And so Ronald Cotton on the left, he was wrongfully convicted of a crime in 1984 by mistaken eyewitness identification. The victim in that case, who was raped, she identified Ronald Cotton as her assailant. The problem with this is that Ronald Cotton ended up being exonerated in 1995 by DNA evidence. The DNA evidence showed that he was not the match, despite being identified through eyewitness ID, and that the person on the right was actually the real assailant. Both Ronald Cotton and the victim in this case, Jennifer Thompson, they currently work together on criminal justice reform. Some of you may have heard of the organization Healing Justice, which is a program that works with victims and exonerees together in cases like this to ensure that we put new policies on the books and really engage in criminal justice reform. And so this is an example of a case that really took the world by storm. I would highly recommend, if you're looking for a new book for your bookshelf, the book Picking Cotton. It was by Ronald Cotton and Jennifer Thompson. They wrote it together. And so as we look at cases, especially in Delaware, this is one of the top factors that we look at. And unfortunately, we do see it quite a bit. Next slide, please. Thank you. So next up is junk science, and junk science, I would say, is kind of this gold standard. And so these are cases that you may see more in the media. You think of things like, arson science, bite mark analysis, fingerprint analysis, blood stain patterns. And so these are sciences that have since been discredited by the National Academy of Forensic Sciences. And so we know that unvalidated or improper use of forensic science played a role in about 50% of wrongful convictions today. It's also the second most common contributing factor to wrongful convictions. And so the problem with the types of forensic sciences that are listed on the right is that over the years, testing and advances in forensic disciplines have really revealed weaknesses in these foundations. The problem with that is there have been so many people that were convicted on these sciences alone. And so now back, in 2025, we're looking at cases from maybe the early 90s, even the 80s, that use one of these types of sciences to convict somebody. And so when we look at the science, especially in cases that we examine at Innocence Project Delaware, we automatically flag that, because that means a person that was convicted on the basis of one of these discredited sciences has now been serving time in prison from anywhere from 20, 30, 40 years. And so when we bring in actual innocence claim on behalf of people that fall under this category, our main argument is that they were convicted on a science that is no longer validated by the forensic science community. And so some examples of that, just quickly, thank you, is that forensic scientists will give misleading testimony by exaggerating evidence, either overstating, understating, making broad kind of accusations about the data and what it holds. And so I would recommend folks to look at the hair microscopy issue that was actually very prevalent in Delaware, probably, if I'm thinking correctly, maybe 10, 15 years ago. And so that was an issue where the FBI actually came out in Delaware, to the state of Delaware, and said that their forensic analysts, and I think it was 72 or 73 cases, had overstated the evidence. And so there was a list of 72, 73 cases that had to go and be reevaluated. And so that's just a really good example of hair microscopy being one of these things. I see a quick question just in the chat, and I'll just address it quickly. So fingerprints are valid. They're still used today, widely used, but there's been science to show that they are not a science that should be used specifically on their own. And so while they can supplement other evidence, they really shouldn't be looked at to be the gold standard for convicting somebody. And so that's a science that's gradually changing over time. It hasn't changed as much as other ones, such as bite mark or hair comparisons, but it's getting to that point. And so while we look at fingerprints, we don't necessarily always trust the science behind them just because of the data and research that we've done.
And I'll also add on, if I could, a really tangible thing that we can analyze it with hair microscopy is the fact that we see cases where someone was convicted based on hair found at the scene of a crime. And this hair did not contain DNA evidence, so it's not an 100% match to someone. Yet at the trial, experts went on the stand and testified that this hair was microscopically similar to the person on trial, and that their hair was found at the scene of the crime. That's pretty damning evidence if your hair was found at the scene of a crime where a murder took place. However, 10, 20, 30 years later, we come to find out through further testing that these hairs that were used to convict someone and sentence them to life in prison were actually dog hair, cat hairs. They're not even human hairs. So just because a hair is microscopically similar, I mean, my hair is long and brown. I bet a lot of you have long brown hair, and our hairs would be microscopically similar. So that's just an example of how this evidence alone should not be enough to convict people, yet has been in past litigation.
So false confessions was the third factor we had listed for common causes of wrongful conviction. And so we know from data and research that folks that experience mental health issues, have intellectual disabilities, and juveniles are particularly susceptible to false confessions. And so one of the questions we always get is, well, if somebody's innocent, why would they confess to a crime they didn't do? And I think if you asked me that question 15 years ago, before I got into this work, I would say to you, I would absolutely never confess to something I didn't do. 15 years into this work, I can tell you that I would absolutely confess to something I didn't do. And the reason for that is because of the tactics that are put in place when police interview suspects of a crime. And so we know that usually folks with certain substance abuse issues, if there are mental issues, they're susceptible to these false confessions because of the tactics that are put in place by their interrogators. And so we know that some of these contributing factors to confessing to a crime that you didn't commit would be things like duress, coercion, mental impairment, fear of violence, threat of a harsher sentence. And so we also know, and we've seen in our cases at Innocence Project Delaware, there are interrogations in cases we're evaluating that have gone over 15 hours. In Delaware, it is happening, and it is shocking to see the tactics that are being used. I put a little blurb in here about the read technique. This is something I would highly recommend folks read upon if you're interested. And so the read technique is something that's utilized by law enforcement agencies across the country. They have a school type that they go in and they train officers even to today. And the purpose of that is to elicit confessions from people. And so some of those tactics that they list to show that a person is guilty of a crime are things like, shaking your leg, if you make too much eye contact, if you don't make enough eye contact, if you sit with your arms crossed. And so these are things that investigators are taught if a person does, then that suggests that they would be guilty. So some of the tactics that they use in these interrogations are things like threats of harm, promises of leniency. So they'll say, well, if you just confess to this crime today, if you sign this, we will let you go home, on a crime that maybe would give 25 to 30 years, you'll only serve 5. Like, I'm here to help you. And so promises of leniency are a big one that we see in our cases. Befriending the suspect, saying, I'm looking out for you. I'm in this with you. Police are not your friends. I hate to have to say that out loud, but they are not. And unfortunately, if you haven't had contact with, the law enforcement organizations and kind of that, those folks in the course of your lifetime, you may not think anything of it. Also minimizing the crime. So saying, well, maybe you did do it, but maybe it was just an accident, right? And so if someone says yes to that, then they can build on this case. And so we know through research and data that innocent people are more likely to talk to police and waive Miranda rights than guilty people. And so this is a really big issue that we see in our work. One of the most famous cases that I'm sure most folks know is the Central Park 5, where 5 juveniles were questioned and ended up eliciting a false confession to a very significant crime. Luckily, those 5 men have since been exonerated, but it took a very long time. And so we know that these tactics are still used in Delaware. And luckily, we had some reforms in place a few years ago that now require recording of interrogations of juveniles and adults. Before that, that wasn't the case, but we're grateful that that is at least something that, Delaware has improved their practices on. Jailhouse informants is one of those resources that is used frequently by the state. And so a jailhouse informant is a person who is in prison. They're incentivized to testify against a defendant in exchange for a benefit. And so that could be a leniency in their own case, or it could be something as simple as getting, more access to the commissary, or maybe having money put on their books. And so we know that the promise or expectation of benefits from the prosecution is very appealing to jailhouse informants. These are people that, are serving sentences on their own and are looking for a way to help themselves. The problem is that not always is it disclosed that jailhouse informants are used at a trial. And so the way they're presented at a trial can suggest that maybe what they're saying is more true than is actually, what's going on. And so unless someone knows that this is a paid jailhouse informant at a trial, they may take this person's testimony for what it's worth. And so they may say, the criminal defendant, I was on the same cell tier as him, and during rec time, he told me that he killed that person. The prosecutor will then take that and present that as evidence at this person's trial. And maybe or maybe not, the jury knows that behind closed doors, this jailhouse informant is getting a benefit for their testimony. And so this is very harmful. It's a very widely used practice in Delaware. We see it again and again in our cases. And unfortunately, it is very damning to the clients that we serve, and it really impacts their fair trial. Inadequate legal defense is one of, it's a pretty common. I will say, as far as inadequate legal defense, we know that the bar, is it's very high. I mean, you have to be a terrible attorney to really be qualified under an effective assistance of counsel. But it's very common. I mean, these are things that, especially for public defenders' offices, we all know they're overworked and they're underfunded and there's lack of investigation. And so most things that fall under ineffective assistance of counsel don't generally contribute to that. I'm talking about attorneys that have fallen asleep at trial, attorneys that we know had shown up drunk to trial, right? And they're not fully representing their clients. Did not perform any sort of investigation. Maybe they visited their client once on a capital case and provided no defense whatsoever. And so these are things that really shock the conscience when you think of them. And so we know that a big part of this is systemic underfunding. And I think it goes obviously for public defenders, but I also think private attorneys are also held to the same standard. And so we know that a promising and effective assistance of counsel claim must still be tied to an actual innocence issue. And so this necessarily would not be the the go-to all for this type of work that we do. But it is seen, but it really has to be something that shocks the conscience to show that the attorney really did not go above and beyond for their client, especially indigent criminal defendants who are really the most vulnerable in our communities and really need the most assistance. And so when we see things that suggest to us that a defense wasn't put on or is intentionally harmful to the client, that's when we start to really look into who that attorney may have been and what problems that would have caused for the client. And so for our purposes, we have to think of it as if the attorney did what they were supposed to do, would the trial have resulted in a different verdict? And so that's usually the analysis we apply when we see things that suggest an ineffective assistance of counsel claim. Official misconduct, this is a very broad category, and this covers prosecutors, police, I would even argue maybe state labs, so anybody that falls under the government. And so we know that in Delaware specifically, there's a lot of protection around police officers. I don't think that's new to anybody on this call. The problem is that it creates a lot of conflict for us. So if you have a police officer that has been, in these series of misconduct or behaviors that are very harmful, unfortunately, they don't go, they go unchecked in Delaware. And so this can be really harmful for folks. We know that Delaware keeps basically all records confidential. And so it makes it really difficult for the public to know when officers are engaging in this misconduct or if they are being held accountable at all. And it's tough for us as Innocence Project Delaware to really conduct thorough investigations on police that are involved in the cases or prosecutors. And so the thing with prosecutorial misconduct is that this would be something when you think of it like you're withholding exculpatory evidence. And so exculpatory evidence is something that may prove a defendant's innocence or reduce their guilt in some way. So if you have prosecutors that are intentionally hiding evidence before trial, known as a Brady violation, these are kind of the typical things that we see or we evaluate when we're looking at cases. But it can also include things like coercing witnesses. And so we have cases where, folks from the family of a client were said they needed to testify against the client because if they didn't do it, they would get their kids taken away because they knew that they had a history with Child Protective Services. And so there's different categories of misconduct that go on. And usually we find out about these things either through word of mouth because someone tells me I was forced to testify. The prosecution told me I had to testify or else something was going to happen to me, my brother, my mother, my father, my sister, and it wasn't worth the fight. And so that's why I testified. And so all these years later, now we're seeing, folks kind of, saying, I do want to recant because when I was pressured to testify, whatever I was saying wasn't true. And I only testified to that because the prosecutors told me what I had to say. And so that's very common in our cases. I will note, because we always get this question, prosecutors are generally not held accountable. So you could do the most egregious things as a prosecutor that would lead to a wrongful conviction. And more than likely, you're not going to be disciplined. There are certain cases where folks are kind of given a slap on the wrist and said, hey, don't do this again. But for a lawyer to go and get disbarred is very rare. And I think the research and data suggests that only about 4% of prosecutors impacted in wrongful conviction cases have ever faced discipline. And so that 4% number is based on convictions going back from 1989. And that's not Delaware. I mean, that's nationwide. So if you think about it in that way, based on the amount of wrongful convictions that we know that have happened, it's a very slim margin. And as far as we know, no prosecutors have ever been held accountable for the 4 exonerees that we currently have in the state of Delaware.
So as Jessica mentioned, we've just learned a lot of factors that contribute to wrongful convictions, but I wanted to talk a bit about why Delaware. Why do we have a wrongful conviction problem and what can we do to address this? So all these factors of wrongful conviction obviously apply on a nationwide scale, but also apply in our state of Delaware. So Delaware's incarceration rate stands out internationally. It's not limited to the most populous cities. People all over the state of Delaware, from Newcastle County all the way down to Sussex, are being locked up and incarcerated at astonishingly high rates. In the past 35 years, only 4 people in the state of Delaware have successfully overturned their convictions based on actual innocence. And it's really important to note that these 4 individuals were all Black men convicted at a relatively young age, and they served an average of 15 years before their conviction was overturned, which is exactly on par with the national average. On average, people serve between 10 and 15 years before their case gets back into court and they get exonerated, which is a very long time to be incarcerated for something that you did not do. Avenues to DNA testing and the gateway to actual innocence is very narrow and very difficult. Jessica will go into depth with this on the next slide. And it's also important to note that Black individuals in Delaware are incarcerated at a rate 5.4 times higher than white individuals. Systemic biases and unequal access to legal resources disproportionately affect Black Delawareans. And as we know, according to the Innocence Project and the National Innocence Network, well more than 50% of exonerees are people of color, and that's no coincidence. And also to say that there have only been 4 people to overturn their convictions in Delaware, but this is not to say that Delaware does not have a wrongful conviction problem. Innocence Project Delaware, we are the only nonprofit organization in the state working to exonerate individuals, and we've only been accepting cases since 2020 for less than 5 years. And these cases take years to investigate, visit clients, talk to witnesses, and actually get back into court and go through the entire court process takes even longer. So while we only have 4 people who have overturned their convictions, according to national statistics, there are about 300 people who are wrongfully convicted sitting in Delaware prisons right now. So it's our job to find those individuals, identify them, fight for their innocence, and assist them post-incarceration on reentry. And all of this to say that Delaware, we're a very small state, the second to smallest state, but we are not immune from issues of wrongful conviction. All of the factors that Jessica mentioned are very prevalent in our state and need to be addressed.
So we use the actual innocence standard to free our clients, and this is going to be a little bit more legalese, and I'm going to try and just make it as basic as possible because this is very complicated. I think even for our team who have years of legal experience and doing this work, it is very difficult. And so the actual innocence standard, we follow the standard that's put forth by the Purnell case, which Sophia will go into during the next slide. And so the actual innocence standard basically says in Delaware that in order for a person to file for a claim of actual innocence, the evidence must be new and sufficiently persuasive. So what that means is that there must be new evidence to support their claim of actual innocence, and it has to be new, so it could not have been presented at trial, and it has to be sufficiently persuasive. And so what that means is that the requirements to prove actual innocence in Delaware is an incredibly high burden for criminal defendants. We know that it's usually impossible to meet, and not because of a lack of, our clients or our team pushing for their freedom, but because the standard is very, very difficult to meet. And so, for an example, after someone is convicted at trial, they can file a direct appeal. On direct appeal, they cannot file ineffective assistance of counsel. So on direct appeal, they can't say, well, my attorney was bad, and so I deserve a new trial. That has to wait until this. So Rule 61 is the first post-conviction motion that is in play. And so they will file this. They have 1 year under the standard, under Rule 61. They have 1 year to file it, and if they don't, they're time barred, which if they're time barred, it means that they can't bring it. And so generally when a Rule 61 comes in, our folks have one bite at the apple. And so what that means is they have to, within the year after they're convicted, they have to go ahead and they have to put everything that they can into why they're innocent and why they deserve a new trial. As you can imagine, this is really difficult. We have, if not the majority of all of our applicants and retained clients do this on their own, pro se. And so you are allowed counsel on a Rule 61 under Delaware. The court can decide that you need counsel on a Rule 61, but they have the entire discretion on that. And so they could find that it's necessary for a person to have counsel on a Rule 61 to help them, or they could find because they need financial need, they can't hire their own private attorney, that they would need a counsel on a Rule 61. But it's at the court's discretion, right? And so it's not always guaranteed. And so what you have here in Delaware and what we see on a daily basis is by the time folks come to us for assistance, they have exhausted all remedies at the state level, and then most of the time have exhausted all remedies at the federal level. So what that means is that everything that they've raised before they reached out to us on Rule 61s, whether they filed 1, 2, 4, or 8 of them, we can no longer evaluate unless it goes through the actual innocence standard. So the actual innocence standard is the gateway for us. So if we know there's new physical evidence, there's new discoverable evidence, that will kind of push us through to get past the barriers that Rule 61 has in place. But it's very difficult to do this. And so there's a lot of frustration from our team specifically, and I think the general community, because the Rule 61s that are being filed and then eventually denied are being filed and written by folks that are in prison. They don't have the resources that legal counsel does on the outside. And so they're really fighting for themselves on the outside, by themselves without any sort of guidance. And as you can imagine, fighting for your life under an actual innocence claim is a very big deal. And we can't expect pro se petitioners to be making that argument in a way that the court is going to grant it. And so what you see is a lot of Rule 61s denied. You see a lot of Rule 61s and innocence claims under that Rule 61 denied. And so our job is to go through and determine what they have raised, what new evidence, if any, that we can make, kind of help their case for innocence. And so that's where those common factors come in. And so we know, for example, if someone has filed Rule 61s on, a science, like a bite mark analysis science, we can now say under actual innocence that, well, that standard has been, the bite mark evidence has since been discredited. And so that's a way for us to get it into actual innocence. But it's not easy. It's very difficult. And I think the biggest part for us that really upsets us with the state of Delaware is that they allow so many Rule 61 petitions to go through, knowing that most of the folks that petition these are pro se, and they don't have the legal knowledge behind what a Rule 61 means. I mean, most folks that reach out to us don't even know they only have 1 year to file a Rule 61. And so they write to us, have not filed Rule 61, and now 18 years later are time barred, right? Because you have a year to file it. And so now they're time barred, they're stuck. And unless we can prove under this actual innocence standard under Purnell that we have new evidence that's sufficiently persuasive, there's really nothing we can do. To answer Chris's question, pro se means on their own. So they're doing it by themselves with no legal counsel. Most of the folks that we work with pursue this route pro se because they have a heavy distrust for the legal community in Delaware. And so we've been told multiple times, I was thinking about getting an attorney or applying for one, but I just thought it would be better to do it myself because I know what I need, and the state of Delaware has let me down so many times. And so that's pretty much the majority of our clients. And so when we get our cases and we look at all of these Rule 61s, it is really disheartening to see that the Delaware court system is still allowing this to happen. And while we do have an actual innocence standard, it's very narrow and it's very difficult, and we have a very hard time fighting on behalf of our clients under this current standard.
And now to get into Mark Purnell's case in 2022, Delaware's actual innocence standard was derived from Mr. Purnell's case. He was wrongfully convicted for murder in 2006 in Wilmington, Delaware, and despite a lack of physical evidence linking him to the crime, he was implicated based on questionable witness testimonies and investigative practices. He was 18 years old when he was convicted and sentenced to at least 45 years of imprisonment. But after serving 15 years in prison, he was exonerated when new evidence emerged, highlighting flaws in the original investigation and prosecution. And you can see Mr. Purnell over on the right as soon as he got released and exonerated from prison in 2022. Purnell versus State is the first case to which the Delaware Supreme Court has found the actual innocence exception to the bar against successive post-conviction motions to apply. Mr. Purnell's case underscores the critical need for vigilance against wrongful convictions and the importance of continual efforts to ensure justice. And I will also add that in his case, 1 week prior to the murder, he had undergone knee surgery, and multiple witnesses and doctors confirmed that he could only walk with the assistance of crutches. Nonetheless, an eyewitness claimed that Mr. Purnell was seen running from the scene, at full speed after a gunshot was fired, which would have been physically impossible. Yet despite this, he was convicted with no physical evidence and faulty eyewitness misidentification.
So this is just kind of a quick graphic to show where we come in the process. And so we try to make it as simplified as possible. This is kind of how we let folks know where we're involved as the Innocence Project Delaware. And so, as I mentioned, you have trial direct appeal, then you have Rule 61. And so we have a little arrow as to the ideal point where we would be able to come in. But that's not necessarily the case, because by the time we get our cases, they've already kind of been procedurally barred because they filed, multiple Rule 61s, and sometimes have had their federal habeas denied as well. And so we know that Innocence Project Delaware can review a case only after trial and direct appeal are over and final. And so we'll kind of go over our intake process and what that looks like and why we do that. But again, by the time most cases come to us, we are really subject to the procedural barriers and the time limits. Luckily for us, we have a very skilled legal team, and we know what we need to look for. We have, policy reforms that we're hoping to, push forward in the state of Delaware. And so we're hoping that over time, this will kind of change. Maybe the burden won't be so hard on people that are wrongfully incarcerated in Delaware. I saw a quick question in a chat about Mark Purnell. Yes, Mark Purnell was granted compensation. Thankfully he was, as far as we know, he's doing well. We're still in contact with him quite a bit. And so we do know that he was compensated. Obviously, compensation does not make up for all the years he spent incarcerated wrongfully, but it does give him a chance to rebuild his life. And so we're very grateful for that development. So we're going to switch gears a little bit for our case intake and screening criteria. And so this is our general how we take cases. And so you have to be wrongfully convicted of a state or federal crime in Delaware. You have to be unable to afford counsel. Your trial and direct appeal are over and final. Currently incarcerated. You have to actually be innocent of the crimes that you were convicted of. And so we have some restrictions on this. And so I'll give you an example. If someone admits or if someone was convicted of raping somebody, but they say that it was consensual, those are cases we don't take. It's very difficult to show that that would have been a consensual act. Another type of case that we really struggle with and generally turn away from are cases of accomplice liability, not because we don't believe in the person's innocence, but because in the court, it is very difficult to separate one person from another in that way and really to determine the intent that was happening at the time of the crime. And then obviously the biggest intake criteria is that there has to be new evidence of innocence. So that could be physical evidence, that could be an alibi that was never introduced to your trial, that could be victim recantations, advanced forensic science developments. And so we have to know that. And also that it's discoverable. We don't see a lot of physical evidence in Delaware, unfortunately. We do have cases where we've discovered it. But physical evidence is not always kept in Delaware, especially for older cases that stem back from the 80s and 90s. And so if we are able to find physical evidence, it is definitely not something that happens often. It is very rare. In the cases that it does happen, it's very exciting because that means that we can pursue DNA testing. But generally, we see our new discoverable evidence as things other than physical evidence. So our evaluation factors, this is just very broad. We obviously look at a lot of things when evaluating a case. Every application that comes in, we look at our current wait time, I would estimate, is probably between 3 and 6 months for an initial screen. And that's mainly because we have a very small team. We have 3 people on our team that handle the casework. And so it can be very overwhelming. And Sophia will talk a little bit about how many applications come in and all the requests for assistance that we receive. But generally, when we look at cases, we look to see if biological evidence still exists. That's always kind of the gold standard for us. Although very rare, we do hope for that in most of our cases. One of the main 6 factors were present. So those are the ones that we talked at the top of the hour, those 6 right there. There are new avenues to investigate. So we could look at a case and say, oh, well, they never talked to an alibi. a trial counsel failed to do that. And so that would be a great thing for us to go ahead and investigate. Evidence availability, again, this really has to do more with age of the case. But if we know that there is a case from 1980, the cards are kind of stacked against us, unfortunately, because most, if not all, evidence from that has probably since been gone for a while. Although I will say we did have a 1984 case we were investigating, and 2 years ago, we learned that all the physical evidence had been sitting at the prothonotary since, and we had no idea. The client had no idea. And so that was a very exciting day for us because we determined that evidence we could probably now try and get DNA testing for. And so it does happen. We take small victories, but when stuff like that happens, it's definitely the exception. And so we're hopeful that maybe that'll continue happening in some of our other cases.
And I noticed a question in the chat. I apologize if I haven't seen all of them, but the most recent one says, are wrongfully convicted individuals compensated for their time spent incarcerated? And luckily, this answer as of September of 2024 is yes. The wrongful compensation bill was passed and signed into law in September 2024, but does not go into active effect until June of 2025. And wrongfully convicted individuals will be eligible to apply for compensation, and that compensation will be $75,000 per year of wrongful incarceration. So while this is a positive step forward and can help individuals rebuild their lives post wrongful conviction, it's not going to make up for all of the years lost, although we are very thankful that we now have this compensation law in place. Delaware is, as far as this law, we were not one of the first states to adopt a compensation law, but our compensation law we do offer a bit more compensation than most other states. The standard for most other states is $50,000 per year of wrongful incarceration, usually capped around $500,000 or $750,000, but Delaware is $75,000 per year of wrongful conviction, although individuals are eligible to apply for more based on other factors and other circumstances. Sorry.
I just wanted to add too, we were one of the last states to have a wrongful compensation law in place, which I think shows, to everybody on this call and just in general in the state of Delaware, we are very behind the times. And as Sophia and I have mentioned, I mean, getting money doesn't, address all the harm that was done. And of course, there's never accountability, right? And so it's not that they give these folks money and also an apology. It's that they give them money, and our hope is that they can, eventually rebuild their lives, but it's never enough. And I think that's true, not just for Delaware, but anywhere where you're getting money. And the other piece too is to consider is, there will be folks that apply for this wrongful compensation through the state of Delaware, and there's an application process. And so it's not automatic. They actually have to apply for it and make the argument for it. But just because you apply for it doesn't necessarily mean you're going to get it. And so that's kind of, I think, a misunderstanding with wrongful compensation, because it is, I think everybody on this call would agree if you're wrongfully incarcerated, you shouldn't have to prove that you need compensation. So even now at this point where we know people have been exonerated, the state has admitted that they were wrongfully incarcerated, they're still making them go through this step to demonstrate why they're eligible for the wrongful compensation. And so it's really, it's a double-edged sword. I think we're very grateful for the compensation, but at the same time, it's also kind of that same mentality that, well, you need to prove to us why you're deserving of the wrongful compensation. And it sounds like a no-brainer. These people were wrongfully incarcerated, and they should have compensation to address the harm that was done to them. And so again, it just kind of stays on brand for the way our criminal legal system works. Sorry, Sophia, go.
No, all good, all good. And to that point, this law was passed, and we are very grateful that hopefully after applying, wrongfully convicted individuals will be eligible for compensation. But this bill doesn't go into effect until June of this year, meaning that every individual in Delaware who has ever been wrongfully convicted to date has been given nothing by the state. They get out of prison, they're released, and often they don't have a support system. It's hard to find a job without experience. And they sometimes don't have a home to go back to, a family to lean on, and rebuilding their life can be very, very difficult, as you can probably imagine. But to date, individuals who are wrongfully convicted have not been given any sort of compensation or settlement by the state, unless they pursue that on their own, going through a settlement like Mark Purnell did. And he was given a settlement in 2024. I wanted to jump a little bit into statistics about our applicant pool. We have 26 active investigations that we believe have merit, but of course, we do our due diligence, sorry, to investigate all of these cases before deciding whether or not to accept these cases as clients. And in order for us to accept cases as clients, there has to be new evidence in the case that is sufficiently persuasive in that it would have changed the outcome of the case had it been presented at the original trial. So with that said, 26 active investigations, 4 retained clients that we have agreed to represent in court and fight for their innocence. We have received 180 applications and we've reviewed these applications, and these are all since 2020. And as Jessica mentioned, 180 applications from incarcerated individuals, and our team has 3 individuals who review these cases. Of course, we have legal interns and individuals and law firms who have stepped up to really help us in our case evaluation and review process. But in totality, there is 3 full-time staff members who are reviewing these cases. So all of that to say, we have our work cut out for us in this state. And 5% of individuals who are incarcerated, according to statistics, are innocent. So we're really just going through all these applications very diligently, investigating them to find out not only which of these individuals who have applied are actually innocent, but are they eligible given our criteria that we can accept and represent them in court? And even if they are eligible, will the evidence that we're able to uncover be persuasive enough to take to court? So these are all things that we have to really consider in deciding which cases we're going to pursue in terms of innocence. The age range of our applicants range from 20 years old to 70 years old. I believe we've only had a couple women apply, so mostly our applicants are male. About 75% identify as Black or African, or sorry, about 69% identify as Black or African American, and 75% are from Newcastle County in Delaware. But of course, we accept and look at applications from Newcastle, Sussex, and Kent County. The longest serving sentence so far among our applicants is 44 years. This was a case that was that this individual was convicted in the early 1980s, and we're investigating his case now. And something that I want to point out, if you look at the top graphic, is that half of our applicants were sentenced to life in prison, but effectively 3/4 of our applicants will spend the rest of their life in prison. And we often see over sentencing in Delaware. You know, we see applicants who apply to us and they have 3 life sentences plus 127 years. And this is not uncommon in Delaware. A lot of the applicants that we look at were convicted of these high profile crimes like rape, arson, murder. So this is really whose cases we look at and what investigations we pursue. And as far as our applicants go, we are receiving new applications every month, every week, sometimes every day. And it's mostly all by word of mouth. That's why we do this kind of thing where we educate our community about Innocence Project Delaware and our mission and how we are fighting for people's innocence, because a lot of people don't know that we're here and don't know that we're doing the work that we are. And when we go down to prison to visit our clients, oftentimes they will tell other fellow incarcerated people about our organization. And that's really how we spread within prisons from word of mouth. You know, someone might say, I'm not innocent, but my cellmate, he's innocent. Let me reach out and get an application for him. And that's how we see a lot of people applying for our services.
And I do just want to add two things. And so, as Sophia mentioned, most of our applicants are serving life without parole sentences. There are quite a few of the cases we're looking at where these folks were originally sentenced to death when Delaware had the death penalty. And then once that was taken away, they were, reduced down to life. The other piece is, it's really interesting. I've worked at other innocence projects before I came to Innocence Project Delaware. And what Sophia said about word of mouth is really how we get our message out. I mean, most of our applicants are people that, you know, have been referred. I think there is some sort of thing of beauty about it, I will say, because we see just from our clients the way that people inside really take care of each other. And so as Sophia mentioned, we may have someone that will say, well, I know that, I'm not innocent, right? But I know so-and-so and my tier is, and is it okay if I have him reach out to you? And so that's the other piece of this too. We like to tell, I had 3 family members reach out to me today over email asking to get assistance for their select family members. And normally we have to send the application to the incarcerated individual. And so unless there's some sort of reason why we would need to send it to a family member, if the person incarcerated is intellectually disabled, or there's some other reason why they wouldn't be able to fill out the application, then we can do that. But generally we require someone to write to us and say, hey, I'm interested in an application. Could you send it to me? And I'll go ahead and send it. The other piece about it, which we didn't cover, is that our application is almost 20 pages long. And so this is, it is a lot of work to put into an application. And we found that it's been really helpful for for them to also understand what happened in their case. And so we use that, this 20-page application, which is never enough. We never judge a case on an application alone. Obviously we read it, then we'll go down and, we'll meet with the person and we'll go over questions we have and kind of what's happened. And we really treat every single application, even if we don't think at first eye view that there's an actual innocence claim, we really make sure every application gets the time it deserves. And as Sophia mentioned, we have a very small staff. And so, we are really looking at these applications in addition to doing all of the other things of the project. But the applications are very important to us. And so I don't know if anyone on this call has somebody that has written to us and they got an application, but if you are on this call, just hang tight. The application is getting reviewed. And we will obviously be in touch as we go through the process. And so I just wanted to give that little background for that.
Thanks, Jess. And I'll also just add quickly to the last point on this slide. Our client who served the longest time to date is 44 years. And as time passes, your chance of getting exonerated decreases, not because you didn't commit the crime and that you're innocent, but simply because evidence is lost over time. Evidence is destroyed over time. Witnesses may not be alive and well today as they were in 1980 for us to speak with an interview. So really, as time goes on, one's chances of getting back into court and getting exonerated decreases. And that's just the unfortunate reality of the work that we do. It has nothing to do with someone's deservingness or their innocence. It really just comes down to the system that we live in and the court processes that need to take place. And if we could go to the next slide, please. I'll quickly talk about our community engagement efforts. We have partnered with the Delaware Law-Related Education Center to launch a wrongful conviction workshop, which is an engaging and interactive program designed for Title I high schools in Delaware. How this works in practice is that a staff member from Innocence Project Delaware, usually myself, will travel to classrooms to teach this workshop for a class period, usually in a social studies classroom, but really any classroom. Students review a Delaware case of an overturned wrongful conviction and present evidence-based arguments in favor or against this person's innocence. And then we get into the conversation of what are the factors in this case and overall that lead to wrongful convictions. And also we learn how Innocence Project Delaware works to address wrongful convictions and overall as a country where we stand in terms of reform and addressing wrongful convictions. So this workshop has been in place since the beginning of the 2024 school year. And if anyone on this call has any connection to a high school in Delaware that would enjoy having their students learn about wrongful convictions, please let me know. I'm happy to go travel all across the state to inform high schoolers about our work. Public education on wrongful convictions is essential to preventing future injustices, strengthening trust in the legal system, and equipping these individuals with knowledge needed to advocate for meaningful criminal justice system reforms. And to that point, we're also having a high school shadow day on April 23rd. Again, please reach out. I will put my email in the chat. after I finish speaking. But we are having a high school shadow day on April 23rd, where students come to our offices at Widener University, Delaware Law School to learn about our work, hear from our Innocence Project Delaware attorneys, meet one of our exonerees who has successfully overturned their conviction, and hear about his lived experiences. So these efforts of educating the next generation of future advocates is really, really important and essential to our mission and what we're striving to achieve now and in the future of Innocence Project Delaware. And I will quickly plug an upcoming event that we have the evening of May 15th. We'll be hosting performances at Wilmington Brew Works, and we'll hear from a couple of local bands. This will be very lighthearted, just to community build, have a laid back evening of music. Food or drink will be available for purchase there. And again, as with all of our events, 100% of the donations will go towards our fight for justice. And I will also put the link for that in the chat very shortly if anyone's interested in joining us at Wilmington Brew Works.
So I know we only have a few minutes left, so I'm not gonna jump in. Can you go back one slide? Thank you. So we're going to just briefly overview policy efforts and reforms just in Delaware, because I mentioned it at the top of the hour. I'm not going to get into all of these just because we don't have enough time, but I do just want to let folks know on the call. So SB 57 and SB 58, these are bills that we're working in conjunction with Senator Kyra Hoffner, and then our state policy folks at the Innocence Project in New York. And so SB 57, we would like to modernize the DNA statute. And so what that means is that SB 57 is going to seek to modernize DNA's post-conviction DNA testing laws, removing the current time bar. So as of right now, folks only have 3 years from the time their conviction is done in final to apply for DNA testing. None of our clients meet that expectation. 3 years is a very short window. And so our goal with SB 57 is to change that and get that time bar removed. So folks that are wrongfully convicted, or even in the early 1980s when DNA testing didn't exist, to go ahead and be able to file for DNA testing. The second one is SB 58. And so this is our new forensic science bill. And so what that will do is it'll provide a formal process for individuals to challenge their convictions when forensic science in their case has been discredited or there were advances in that science. And so these are currently going through the process right now. They've just been assigned to the Senate Corrections and Public Safety Committee. You can read about them online if you're interested, but those are some of the policy reforms that we're working on right now in conjunction with our friends. And so it's very exciting. And we're lucky to have the support of Senator Hoffner and others in the state to try and make these bills happen.
And I won't dive too deep into any of these for the sake of time, but I just wanted to mention here are some resources to learn, watch, read, and listen to if anyone wants to learn more about our work and broadly wrongful convictions and exonerations in general.
Thank you, both Sophia and Jess. This was an incredible presentation. I've been getting messages of folks saying, this is so good. Thank you for putting this on while you guys are talking. So really, really fabulous. Folks, you asked really great questions. If you do have more questions following this, please do. Sophia dropped her email in the chat. If you don't catch it, feel free to email myself with the ACLU. Glad to share it. Definitely get engaged with them. This is really important work. We're really thrilled to be partners with you in this state, and just really appreciative of all of the work you do. I'm going to drop one more time the form for CLE codes. And Mira, if you could throw that PowerPoint back up with the last slide. I'll read it for folks while she gets that. If you are here for CLE credit, you need our second code, and that code is RWJ091. RWJ091. So if you are here for CLE credit, please submit that to the form. And there was a question, slides. Are slides able to be emailed out following?
Generally, we don't share, not because we don't want folks to get the information, but generally because they're a work product of ours. But if you're interested in resources, we have a ton of resources that we can email you that have this kind of in a packet form that we give to folks that are interested in our work. We'd be happy to send those over to you.
Fabulous. So yes, please get in touch if you have questions, want to get engaged, want to help, want to do something. Please do. We highly encourage you. And thank you so much for spending this hour with us. We're really glad to have had you. Thank you so much, everyone.
Thank you all for joining today and learning about Innocence Project Delaware.
Thank you.